in Pune Porsche accident case has now been sent to a rehabilitation home until June 5th. This comes in as there was a public uproar over the accident that took place in Kalyani Nagar early on Sunday morning. In fact, the current three-judge bench of the Juvenile Justice Board set aside the bail order that was granted on Sunday. As per the bail order of Sunday, the accused in this case was asked to write a 300-word essay on the accident. Following it, he was also asked to help and assist the Yerwara traffic police and seek psychiatric help for his drinking habit. He was also asked to approach a doctor in this case. However, there was a public uproar over this case in Punekars, which is where the Pune police also reached out to the Sessions Court yesterday, seeking to cancel his bail and also to try the accused as an adult. However, considering that the purview of this case falls on the Juvenile Justice Board, because the accused in this case is 17 years, 8 months old, which is why the Sessions Court had directed the police to reach out to the Juvenile Justice Board. After a day-long hearing, the Juvenile Justice Board has sent the accused to remand home, whereas in the case of him being tried as an adult, the hearing would take place only after 3 months. As per the information provided by the lawyer of the accused, it is mentioned that within 30 days is where the cops will have to file a charge sheet in this case, following which the report of the psychiatric help that the accused would seek would also be presented before the Juvenile Justice Board. They will analyze all of these aspects, and only after 90 days or 3 months is where the decision would be taken when it comes to him being tried as an adult. Apart from that, we also see that the Pune police has made some amendments to the FIR, wherein instead of 304, the accused has also been charged under 304 and not 304A. Apart from that, the father of the accused has also been arrested by police. He was produced before the Sessions Court today and has been sent to police remand until May 24th, which is where he will also be questioned. He is also been charged under 304 and the Juvenile Justice Act. All of these aspects are a part of the Pune Police's investigation. However, it is a big win for Pune Police because they had said that they would be approaching the court to try the accused as an adult, though that has not taken place, but the bail of the accused stands on hold because the earlier order has been set aside by the current Juvenile Justice Board. The earlier order was passed by a one-member bench which had to be ratified within 7 days, which did not happen, but in this case, the order today has been passed by a three-judge bench of the Juvenile Justice Board. Prashant Patil with us. Prashant Patil is the lawyer who's represented accused. So what was the order that was passed in this case? What were the arguments that were put forward?
Today what the position of law is, on 19th May 2024, this particular CCL, the Child in Conflict in Law, was released on bail by the order of the Honorable Juvenile Justice Board. That particular order was challenged by the police in a review application under section 104 of Juvenile Justice Act. We argued at length, we opposed that particular application. We submitted certain law points. The prosecution too submitted their law points. Based on all the arguments, the Juvenile Justice Board today has directed the Child in Conflict in Law to stay at a rehab home for a period of till 5th June 2024.
Sir, when you speak of these arguments, the police also want to try him as an adult. What was the status quo? What's the status of that application right now?
See, the scheme of Juvenile Justice Act is very clear. Today an application was moved by the police before the Honorable Juvenile Justice Board. They wanted to treat the child in conflict in law as an adult. However, the scheme of the act is very clear. It says that whenever a child in conflict in law is arrested by the police or an FIR is registered against the child in conflict in law, within a period of 30 days, a charge sheet has to be filed. Post filing of the charge sheet, it is not mandatory for the child in conflict in law to stay at the detention home. Post 30 days, every 15 days the Juvenile Justice Board takes a report, a compliance report of a psychiatrist or a psychologist or a social behavioral agency, anyone. Post that, it's a period of 60 days that the Juvenile Justice Board then decides whether at this stage the minor can be treated as an adult or it has to be continued to be treated as minor. So that procedure from now is almost 2 to 3 months. So we'll have to wait for that time to come.
So will you be appealing against the current board order in a higher court?
See, we have not got the entire order today. The entire order will come only tomorrow. Once we get the entire order, the certified copy of the order, we will sit with our clients and take a conscious call on it.
So, and what are the provisions that the parents would they be allowed to meet the accused while he is in the remand home?
See, under the Juvenile Justice Act, every child in conflict in law who has been detained at a rehab home, he has a mandatory right, as a fundamental right, to meet one family member at least twice a week.
So what does the act say when it comes to further extension after this 14 days? Will he be further kept in the remand home, or will there be a review? How does it work?
That is completely the discretion of the Honorable Court. Even after 14 days, if the Honorable Court wants to extend, they can extend the detention, or if the Honorable Court comes to a conclusion after 14 days that this is enough and he can be released after that. That is completely post 14 days will decide.
And Prashant Patil was speaking about the accused's status.